What Daniel Reyes lost that evening was not the 8,360 it took to make his van usable again. It was the look on his son's face before money taught that boy what contempt sounded like. I want you to hold on to that for the next few minutes, because everything I'm about to tell you points back to that one thing, and none of it brought it back. After I finished the sentence, nobody moved for a few seconds. I could hear the clerk's fingers leave the keyboard. I could see a paper cup on the defense table leaving a wet ring on the wood. That silence is where this story ends. I want to tell you how I arrived there. There were 3 moments in that courtroom when the room went fully still, not the quiet between questions, not the pause while a lawyer finds a page. I mean the kind of silence that settles when something true has entered the room and nobody can push it back out. I remember all 3 of them. I have carried all 3. Subscribe, not for me, for the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. When Daniel first walked into my courtroom, I noticed the way he stopped half a step before the rail, as if he wanted to make sure he was not taking up more space than he had been given. I have seen that before. People who have spent too long apologizing for being where life has put them move that way. His shirt was clean, but one cuff was frayed. He kept one hand on a manila folder and the other flat against his thigh to stop it from shaking. The small thing I have never forgotten is that when he sat down, he tucked the loose strap of his watch under the band without even looking at it. He was trying to hold himself together with motions so practiced they had become invisible to him. Graham Whitmore entered very differently. He came in with a lawyer, a leather folio, and the kind of calm that money gives people when they have spent years believing inconvenience is the same thing as injustice. His eyes went first to the clock, then to me, then to the empty space where he expected to be treated as an exception. He never looked at Daniel for more than a second at a time unless Daniel was speaking. Then he watched him too closely. The one human thing I noticed in Graham came before the hearing started. Mateo Reyes coughed in the back row, and Graham turned toward the sound right away. He knew a child was in that room. He knew a child was close enough to hear. That made everything worse. The incident happened on Saturday, March 11, 2023 at 5:42 p.m. at the exit lane of the Harbor View Market parking garage on Dorrance Street in Providence. Daniel Reyes was 35 then. He was raising his 8-year-old son Mateo, alone after Mateo's mother died 2 years earlier. He had just bought groceries before heading to a night shift cleaning offices downtown. He drove a 2009 Honda Odyssey with 186,000 miles on it. It stalled on the incline just before the gate arm. Behind him was Graham Whitmore in a black 2022 Mercedes S580. Graham was 52, wealthy enough to believe waiting was something other people were supposed to do for him. Security footage showed he had room to wait. 12 feet, then 9, then 6. He used the horn 7 times in 18 seconds. Daniel got out, lifted both hands, and tried to signal that the van had died. Mateo stayed buckled in the back seat with 2 grocery bags beside him. What happened next came in through testimony, video, repair photos, and the kind of details people only remember when a day should have remained ordinary and did not. Graham rolled forward once, touched the rear bumper of Daniel's van, backed up a foot, and rolled forward again harder. The second hit pushed the van into the striped gate post and cracked a taillight. Daniel turned around fast. Mateo started crying. A garage attendant left his booth and ran toward them. 2 witnesses heard Graham get out of the Mercedes and say, "If you can't afford a working car, you shouldn't have kids." One heard him say, "I pay more in taxes in a month than you make in a year." Daniel said he tried to keep his own voice low because Mateo was in the van. Graham took out his phone and started recording. He said, "People like you hold up the whole city." Daniel got Mateo out because the boy was crying so hard he could not catch his breath. Graham then said, "A man in your position should be grateful I even stopped." By the time the file reached me, the law had given the harm neat names: reckless driving, disorderly conduct, harassment, restitution for property damage. A motion from defense counsel to separate the vehicle contact from the language, as if the bumper and the words had happened in different worlds. That is one of the things paperwork does. It cuts a living thing into pieces so a court can hold it. Necessary work, imperfect work. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe. Stay with it. There is a legal detail most people do not know. When I suspend a license from the bench in a case tied to the use of a car, the order does not just float out into the air. The clerk transmits it to the registry before the person reaches the parking lot. On paper, the privilege to drive can end before the engine turns over. The law moves slowly in some ways. In that one, it moves fast. Another thing most people never see is how a case first looks on a judge's desk. There is no music to it. No sign that a moral wound is hiding in the stack. Just copies, a complaint sheet, a damage estimate, a disc with garage footage, a typed police narrative where a human injury has been squeezed into short lines and blank boxes. I remember pausing over the words, minor child present. The law could name the child's presence. It could not name what the child had heard. I could order consequences. I could not give Mateo Reyes back the version of his father he had before that day. When Daniel entered for the hearing, he came through the side door with his sister Rosa behind him and Mateo beside her in a navy sweater. Daniel's eyes went first to the clerk, then to me, then to the empty chair at counsel table, as if he needed to know how close the man would be sitting. What nobody else in that room could see the way I could see it was Daniel's left hand. He had pressed his thumbnail so hard into the side of his finger that the skin had gone white. He kept doing it until he sat down. Graham came in 2 minutes later through the front door with his lawyer and an assistant carrying a file box. He was not late. Men like Graham are rarely late in rooms where lateness might be held against them. From where I sat, I could see something nobody else could see as clearly. Before he took his seat, he looked past counsel table to the back row where Mateo was sitting and then adjusted his tie. It was quick, almost nothing, but it told me he had already begun arranging himself for the child's eyes. I remember the first silence because it arrived before most people in that room understood it had begun. Daniel was sworn in. His voice was steady on his name, steady on his address, steady when he told me what kind of work he did and what shift he had been trying to make that night. Then the city attorney asked what he remembered most clearly from the garage. Daniel did not say the bumper. He did not say the phone. He said, "My son apologized to me all the way home." The room stopped. The clerk did not type for maybe 6 seconds. One of the officers at the back shifted his weight and then went still. Graham's lawyer lowered her pen and looked down at nothing. Silence. One was thin and clean, like glass. Nobody wanted to be the first person to touch it. When the city attorney finally spoke again, he did it more softly. After that silence, I understood that the case was not about a broken van with ugly words tied to it. It was about a child who had mistaken humiliation for his own fault. The first evidence came in around that silence. We watched the garage video twice, the first time for sequence, the second time for distance. Daniel's van stalled at 5:42:11. Graham's horn started at 5:42:19. First contact at 5:42:37. Second contact at 5:42:41. The garage attendant, Samuel Price, testified there was enough room behind the Mercedes for Graham to wait safely. Repair photos showed black paint transfer on the Odyssey's rear bumper and a cracked left taillight, with the scrape on the gatepost rising at an angle that matched the push. Samuel said one thing I wrote down in my own handwriting. He said, "The little boy kept picking up oranges and putting them back in the bag." I looked at that sentence for a long time in my notes. It did not prove an element of a charge, but it told me exactly what kind of room I was sitting in and exactly what had happened inside that child while the adults were still speaking. We admitted Daniel's repair estimate, his missed shift wage statement, and a counseling invoice from a child therapist who saw Mateo 4 times after the incident. Defense counsel objected to the counseling invoice. She said it reached too far beyond the traffic conduct itself. I listened carefully, because lawyers are supposed to make those arguments when the law gives them room. But in plain language, If a man uses a car and his voice together to corner another man in front of a child, I am not going to pretend the child heard only the bumper. Daniel was not polished. That mattered to me. Good witnesses are rarely polished. They sound like people still trying to understand why the day went the way it did. When defense counsel asked whether Graham had ever touched Mateo, Daniel said, "No." When she said the video had no audio for the first impact, Daniel said, "That's true." When she said, "So some of what you are telling us depends on memory," Daniel said, "Yes, ma'am, and I wish it didn't. If something in what I have said so far has stayed in your chest, subscribe. Because what I'm about to tell you next will stay longer. Subscribe now, and then let me keep going." Graham took the stand after lunch. Before he did, I watched him at counsel table while the clerk marked exhibits. He had a habit of placing his thumb over the face of his watch whenever someone mentioned Daniel's income. He did it 3 times. The body tells the truth before the mouth gets there. People do not always know that from where they are sitting. I knew it from where I was sitting. He began carefully. He said he was sorry there had been an unpleasant scene. He said he had not meant to make contact with Daniel's van and that the incline was steeper than it looked on video. He said he had used language I would not choose again. He said he had been frustrated because he had a dinner reservation and an elderly business associate waiting. I heard all of it. I weighed all of it. The defense came close to giving me pause at one point. Counsel introduced a service record showing Daniel's van had a transmission issue 2 months before the incident. She argued that a stalled van on an incline can roll backward in short movements. That is true. Machines do fail in inconvenient ways. For a few minutes, I sat with the possibility that the first contact might have been less deliberate than it looked. Careful decisions require that kind of sitting. Then the city replayed the video frame by frame. The brake lights on the Mercedes brightened before the first touch, then went dark. Then the nose of the car dipped forward on the second impact in a way that told its own story. After that came Graham's own words. They ended the pause. He said, "I did not think words counted if nobody laid a hand on him." He said it quietly. He said it as if he were offering the court a sensible limit. The room did not move then, but it had not yet reached silence too. That sentence told me he believed harm begins only where skin begins. Men who believe that leave a wide field of damage behind them and still call themselves innocent. A little later, his lawyer asked what he had meant when he spoke in front of the child. Graham said, "I feel for what he is dealing with, Judge, but I was trying to teach the boy that the world won't wait for weakness." I wrote that down. I looked at it for a long time before I moved on to the next page. There are sentences that arrive wearing sympathy and carrying contempt inside them. That was one. Then came silence too. It happened at the end of Graham's testimony, after his lawyer had no more questions and after the city attorney asked one last thing. The city attorney said, "Did it occur to you that the child in that garage might remember your words longer than the traffic delay?" Graham looked at me instead of at the lawyer and said, "Someone had to be honest with him." Then he stopped speaking. The quiet that followed was nothing like silence one. Silence one had been tender, almost protective, as if the room had leaned toward Daniel without meaning to. Silence two was colder, heavier at the bottom. I could hear the air vent above the jury box, though there was no jury in that room. Nobody broke this silence quickly because the room had understood something it could not misunderstand now. Graham did not think he had lost his temper. He thought he had fulfilled a duty. "Subscribe before I go further. I have more to tell. And the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. There is a memory from my own life that came back to me while Graham was still on the stand. I was 12 years old. My father took me to a shoe store on Broad Street before school started because my toes were pressing against leather that had done all it could do. He picked up a pair, looked at the price, and put it back. He smiled at me like nothing had happened. Then he knelt, pressed the front of my old shoe with his thumb, and said, "We've got 1 more month in these." Outside, the bakery next door was letting out the smell of warm bread. We walked home without speaking much. I can still hear the sound my soles made on the sidewalk. When I returned to the case, the facts were where I had left them, but the room had changed. Graham's last sentence had taken away any shelter of misunderstanding. The defense did what defense counsel should do. She argued that her client's speech was rude, not criminal. She argued that the state was trying to punish status, not conduct. She argued that a wealthy defendant saying an ugly thing is still entitled to the same line between bad manners and unlawful behavior as anyone else. She was right to make me walk that line carefully. And I did. I considered whether the harassment count had been overdrawn. I considered whether the sentence should rest more heavily on the vehicle contact and less on the words that followed. I considered the lack of prior criminal history. I considered that Graham had remained at the scene and provided his information. Courts are supposed to consider the whole person, even when the whole person has done something mean in a room full of witnesses. But what ended the pause in me was simple. He had used the car as pressure. He had used the words as a blade. He had used the child as an audience. Those things together are not an accident of temper. They are a choice in sequence. And the law, imperfect as it is, still knows something about sequences. After closing arguments, I took a short recess before I ruled. In chambers, I looked again at my notes. I looked at Daniel's wage statement, 4 missed shifts because the van was in the shop. I looked at the counseling bill. I looked again at the sentence in my handwriting. The little boy kept picking up oranges and putting them back in the bag. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. When I came back out, everyone stood, then everyone sat. I gave the verdict first because that is how the room needed to move, carefully, in order. I found Graham Whitmore guilty of reckless driving, guilty of disorderly conduct, and guilty of harassment. I found the second vehicle contact intentional and the first reckless. I found that the words were not separate from the conduct, but part of the same act of intimidation. I have not told you what I ordered yet. I am about to. Subscribe before I do. Not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. I had made that decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. From where I sat, the room looked both crowded and far away. One deputy had both hands clasped in front of him. The city attorney had stopped touching his files. Daniel's sister had placed her hand over Mateo's knee without looking down. Air can feel thin in a courtroom when something permanent is about to be spoken. It felt that way then. I said, "Mr. Whitmore, I am ordering you to pay a fine of $25,000 to the Rhode Island Family Transportation Relief Fund." I said, "I am doing that because you used impatience over a stalled family vehicle as an excuse to punish a man for being poor in front of his son. Money will not repair dignity, but it can be directed toward the place where this harm began." I said, "I am also ordering restitution in the amount of $9,000 to Daniel Reyes." I said that amount covers the van repair, a rental vehicle, 4 missed shifts, and 12 counseling sessions for Mateo Reyes. Restitution is not charity. It is the plain cost of damage you caused and then tried to describe as instruction. I said, "I am suspending your driver's license for 18 months. I said, "For 18 months, you will not drive yourself to your office, your dinners, your meetings, or any other place where you may be tempted to confuse delay with permission. A car is a moving piece of trust. You handled that trust like it belonged only to you." I said, "I am ordering 300 hours of community service at the Providence Fatherhood Resource Center and the intake desk of St. Mary's Family Shelter." I said, "You will work where fathers wait with children, where missed buses matter, and where broken cars become broken weeks. Not because humility can be assigned like homework, but because proximity is sometimes the first honest teacher." Then I said, "There is one more thing." I let that sit for a moment. Then I said, "Within 30 days, you will stand in the community room at the Providence Fatherhood Resource Center in front of enrolled fathers, staff members, and any local press who choose to attend, and you will read a written statement approved by this court. That statement will name Daniel Reyes. It will describe what you said. It will not contain the word if, and it will not contain the word but. Then I said, and there is one more part still. You will fund in full a reliable replacement vehicle for Daniel Reyes up to $22,000 to be selected by him through a court-monitored process within 60 days. I said, what he needs now is not your opinion of resilience. He needs transportation he does not have to fear each time he turns the key. I also entered a no-contact order for Daniel and Mateo outside the public apology required by the court. Then I spoke to Graham directly. I said, what you did here can be measured in repair invoices, counseling bills, and hours lost from work, but that is not the whole measure. I said, you taught a child, for a few terrible minutes, that a man with money could decide what another man was worth in front of him. I said, to your family, who now have to live near the consequences of your choices, I have no accusation and no false comfort. I said, this court will not let Daniel Reyes become a lesson in helplessness for his son. Thank you for staying with this. I mean it in the specific way you mean something when it cost you something to say. Subscribe if you have not yet. You already know why you are still here. Silence. 3 arrived fully after that. It lasted longer than the others. I did not time it, but I know it passed through at least 3 full breaths before anyone moved. Daniel kept one hand on the table. Graham stared straight ahead. His lawyer closed her file without looking at him. Mateo in the back row leaned against his aunt for the first time all afternoon. When the silence broke, it broke softly. Daniel turned, bent toward his son, and said, you don't have to say sorry for me anymore. I have said that sentence back to myself more than once since the case closed. As the courtroom began to empty, I remained seated on the bench, signing the last pages that make spoken consequence real in the world. Daniel did not go to the cameras waiting outside. He went first to Mateo. He put his hand on the back of the boy's head and kept it there while Rosa gathered the folder and the sweater they had brought. I was close enough to hear Rosa say, he heard you, baby. Then the 3 of them moved toward the hallway together. The appeal was filed 19 days later. It went to Rhode Island Superior Court. The defense argued that the sentence was excessive, that the public apology was improperly humiliating, and that the replacement vehicle order went too far. The Superior Court affirmed the sentence in all material respects. In plain language, the appellate judge said my orders were directly tied to the harm proved in court and were meant to repair, restrict, and deter. The process took 13 months. When I read the ruling, my response was brief and honest, good. On February 12, 2025, I received a compliance update from the Providence Fatherhood Resource Center. It included one photograph taken in the supply room at 6:04 p.m. Graham Whitmore was on one knee in work gloves, tightening the wheel on a used blue bicycle, while a little boy in a red hoodie stood beside him with both hands on the handlebars. I looked at that photograph for a while. Then I placed it back in the file. The question that case left me with was never whether the sentence was lawful. I knew how to answer that. The question was smaller and harder. What does a child do with the first moment he sees his parent treated as less than human, and the parent cannot stop it in time? I do not know the full answer. I have turned that question over many times. I suspect most of us are living inside some part of the answer without saying so. To those of you who know the feeling I recognized in Daniel's face, I want to speak carefully. I do not mean fear. I do not mean shame exactly. I mean that smaller, tighter thing that happens when you are trying to remain calm because someone you love is watching, and you know if you break, they will carry the sound of it home with them. I saw that in him. If that feeling lives in you, then you know how much strength it takes to stay soft when the world invites you to harden in front of your child. And to those of you who have ever occupied the space Graham occupied that day, whether by money, title, education, or plain habit, there is one question I wanted to ask him from the bench but could not because it was not a legal question. When did you decide that your delay gave you the right to shape another person's child? If you do not like the answer that rises in you, here is one thing to do next. Go sit one afternoon where families wait for help and keep your mouth closed long enough to learn the cost of one careless sentence. I still remember the look on Daniel Reyes's face when he realized I was not going to ask him to be smaller for the comfort of the man who had already tried that once. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you leave something in the comments, leave something that sounds like a room where people who still know how to see each other clearly can find one another.